Good morning, everybody, and welcome, both for those people who are here live in Philadelphia and for those who are joining us via web. I'm Shannon Farmer, and today we're going to be talking about the Labor and Employment Law Year in Review, along with my colleagues, Carolyn Pellegrini and Elisa Hood. So we are going to go ahead and get started. For those of you who are on the webinar, if you have questions, you can feel free to email them in the Q&A section, and if we can't get to them live during this presentation, we'll follow up with you via email afterwards. For those of you who are live here in Philadelphia, please feel free to ask questions as we go along. We'll get to as many as we can, and if we run out of time, we'll be happy to talk to you up front afterward. And one other thing I should mention is, in addition to offering CLE credits when we do these things, Ballard is now going to have SHRM credits available for those of you who are members of SHRM who want those credits, and you can talk to the folks up front when you came in about how to do that. All right, so what are we going to talk about today, and where sort of have we been? If you attended this program last year, the big things we were talking about were EEOC trends, the new NLRB, legislative developments relating to the FMLA and affirmative action, and some notable Supreme Court decisions. You'll see some parallel trends here because we're going to be talking about some, but not all of the same things. And since that time, we had major Supreme Court decisions regarding the ACA and the contraceptive mandate and the invalidity of NLRB recess appointments. This year, we're going to be talking about pregnancy as a disability and pregnancy accommodation because that is a very hot area at the moment, religious accommodation, same-sex marriage issues, a bunch of activity on the OFOCP front, and ACA subsidies, among other things. And you can see the topics here that we're going to hit, but that's a bunch of what we're going to talk about. And the first thing we're going to talk about is discrimination and protected classes, and for that, I'm going to turn it over to Carolyn.
Good morning, everybody. Thanks for coming. So one of the big updates that we're seeing in discrimination and protected classes is the addition of sexual orientation and transgender, also called gender identity, to a lot of state and local laws as well as agencies. So we just wanted to quickly review that sexual orientation is widely accepted by the courts and by the EEOC as unlawful sex discrimination. You'll recall that Title VII, which sets forth many of the protected classes, doesn't specifically say that sexual orientation or that gender identity are protected classes, but we've seen the courts and the EEOC both wholly accept that sexual orientation discrimination is unlawful because it generally deals with a person's failure to conform to sex stereotypes. On the other hand, transgender is not necessarily as clear. We're seeing at the agency level that the EEOC is issuing agency determinations stating that gender identity is discrimination, and that's unlawful under Title VII because it is because of sex. And as you know, Title VII says that discrimination based on sex is unlawful discrimination. So the EEOC is processing charges that deal with discrimination based on gender, gender expression, and gender identity. Now, again, when it comes to transgender, the courts have not yet accepted the EEOC's position, mostly because a lot of courts just simply haven't had those cases yet and haven't had to deal with it. But again, we do want people to be aware that there are a lot of state and local laws that do protect based on sexual orientation and gender identity, especially in this area. So New Jersey and Delaware both have state laws that protect against discrimination based on sexual orientation and gender identity, as well as the city of Philadelphia. So even though Pennsylvania itself doesn't have a state law, the city of Philadelphia does have an ordinance that protects on both of those.
And just one practice tip as it relates to this issue of sexual orientation discrimination. If you're defending a complaint that simply says that somebody was discriminated, against on the basis of their sexual orientation, that should not be sufficient in the way that the courts have recognized this. The plaintiff is still going to have to be able to make out the case that it wasn't just on sexual orientation, it was this failure to conform to sex stereotypes. So it is, in many cases, a distinction without a difference, but it does make a litigation difference because they still have to evince the facts that it was sexual stereotyping, not sexual orientation in and of itself, because that is not protected by Title VII. Although there have been various efforts in Congress to make it protected, they haven't gone anywhere.
So the other thing that we wanted to talk about regarding sex discrimination and protected classes is the widely publicized multiple court cases about same-sex marriage. A lot of you will recall that there was a Supreme Court case that struck down the Federal Defense of Marriage Act. The important thing to remember about that case is that the Supreme Court wasn't deciding whether or not same-sex marriage is acceptable. What the Supreme Court was actually deciding, and what their decision was based upon, is whether the federal government could determine whether same-sex marriage is acceptable or not. So basically what the court said is that's not for the federal government to determine, that's for the states to determine. So that's why you're seeing now all of these separate state and circuit court decisions about same-sex marriage.
And one of the things to note here is the impact of United States versus Windsor, which again really just dealt with whether the federal government could say, for purposes of federal law, that marriage is only a man, as defined as being between a man and a woman, had huge impacts in a lot of benefit issues, ERISA, for example, the tax code, and most of those, I think, have been clarified by Windsor, and they've dealt with it pretty well. The area that is still subject to a lot of confusion and uncertainty is as it relates to the Family and Medical Leave Act. And that is because under the Family and Medical Leave Act, under the regulations, spouse is defined as married under the law in which the employee lives, not works, lives. So while we have this patchwork of state law provisions, we have a situation where, for example, if you're an employer in Pennsylvania and you have employees who live in New Jersey, who live in New York, who live in Pennsylvania, up until recently, when Pennsylvania, under the Wolf case, struck down its ban on same-sex marriage, you would have a situation where the same employer, employees working next to each other in the same location, if a same-sex spouse became ill, the employee who lived in New Jersey could take FMLA, the employee who lived in Pennsylvania could not. Now, many employers were dealing with that by saying, well, we're going to give leave equivalent to FMLA, and because this still exists, many employers still are, but the problem is if you give what I'll call FMLA-like benefits that are not within the definition of the FMLA, you cannot count them against an employee's leave entitlement under the FMLA, just as if you gave somebody that kind of leave before they met the eligibility requirements for the FMLA. You know, somebody who's pregnant, gives birth, wants to take leave when they've only been with your company for 6 months, that's not FMLA. You can give the leave. You can't count it against their entitlement when they become entitled to the FMLA benefits at a year. So it's put employers in a very difficult situation. Recognizing that, the U.S. Department of Labor proposed regulations in the summer of 2014, excuse me, that would basically say, you know, any same-sex marriage we're going to recognize. But they've never been finalized. Comment period, 45 days, they've never been issued. You know, there was some suggestion that they were waiting until after the election to do any controversial regulations. I'll say that again later when we talk about some other regulations that we're waiting for from the Department of Labor. And I don't know if the delay in issuing them at this point is because of what's been going on in the courts and the number of court decisions, which Carolyn's going to talk about briefly in a second, that have struck it down, saying, you know, soon it's not going to matter. and now the Supreme Court's going to address the issue. So I don't know if that's why they have tried to just stay out of this issue, but we still have a situation where whether somebody is entitled to FMLA for a same-sex spouse depends entirely on the state in which the employee lives, not where they work. So it's just something to keep in mind where you've got employees who reside in different states, especially once you get out of the Northeast, because the Northeast now, I think entirely uniformly, is recognizing same-sex marriage. So we don't have that problem, but there's other parts of the country where that is not the case.
So as Shannon said, that there was the court case of Whitewood versus Wolf in Pennsylvania, which struck down Pennsylvania's Defense of Marriage Act, which was passed in 1996. So that is one of many of the state and local cases that you're seeing that are dealing with this issue that the Supreme Court really bounced back to the states through United States versus Windsor. So we're now at kind of a crossroads that we're hoping that the Supreme Court is really going to help us out with. The important thing to remember here is that there's a twofold issue here. There are two questions that are going up to the Supreme Court, and there are two questions that are raised by all of these laws. The first one is, can a state refuse to allow same-sex couples to marry? And that's a fundamental right. That's what the argument is that the fundamental right to marry under the U.S. Constitution says we can. Now, the second issue is whether or not a state has to recognize a same-sex marriage that was performed in a jurisdiction where same-sex marriage is lawful. And so that really implicates the full faith and credit clause. And so we have kind of this hodgepodge across the country about who is allowed to marry, who is not allowed to marry. And then you have the lovely states of Missouri who will recognize a same-sex marriage from another jurisdiction, but they will not allow people to marry. And then you have Montana who will allow same-sex couples to marry, but they won't recognize a marriage from another jurisdiction where it's legal. So it really just kind of comes into a hodgepodge, as I said, and you end up with this circuit split. So you have the 4th, the 7th, and the 10th circuit saying, look, you have to allow people to marry, and you have to recognize marriages that were lawful in the jurisdictions in which they were performed. And then you have the 6th Circuit, who recently said yes to both questions. You can refuse to let people marry, and you don't have to recognize marriages that were performed in other jurisdictions. So now we have the Supreme Court case that is coming up, and it's really lovely to pronounce. I believe it's Obergefell versus Hodges, and that's really a culmination of 4 cases, each coming out of the states that the 6th Circuit covers, and that's Ohio, Tennessee, Michigan, and Kentucky. And so that is scheduled to go up to the Supreme Court, and they're going to hold a hearing, and what we're hoping is that we're going to get a very clear decision from the Supreme Court on both of these questions, and even if it's just the first, that pretty much trumps everything, and to just kind of give us some guidance to really take away this patchwork that we're seeing across the country.
And based on the events of this week, I think most commentators are speculating that the Supreme Court, in fact, is going to find that states cannot refuse to allow same-sex couples to marry. If you haven't seen it in the paper, Alabama went to the Supreme Court and said, please issue a stay of same-sex marriages pending your decision in Hodges. And you know, not unexpected that the Supreme Court would do that. In fact, I think most people expected the Supreme Court to grant the stay because it's often the case that they'll stay situations like that when they're going to take up the issue. The Supreme Court refused. And so most commentators have said, well, that's the court basically saying we're going to strike down laws that prohibit same-sex marriage. And in fact, the 2 dissenting justices on the order denying the stay said essentially just that. The argument here is very similar to Loving versus Virginia, which was the case many decades ago where the Supreme Court said, look, states, yeah, you normally get to regulate marriage, but you can't prohibit people of different races from marrying because it's a fundamental right. And for those who have read the Windsor decision, although the court was very careful in Windsor to say, we're not deciding the issue of whether states could prohibit same-sex marriage, we're just saying the federal government can't do it because it's a state right. The other language in that case about the stigma attached and the fun, and the importance of marriage and all of those things have really led people to believe that it's very hard for the court to reconcile the language in Windsor and it's the way it talks about marriage and the harm that is done by having the federal government prohibit same-sex marriage with the court saying, no, but states can do it. So I think it's widely expected that Hodges is going to put an end to all of this litigation and same-sex marriage is just going to be legal in the U.S. And I think for, practitioners and employers everywhere, having the certainty, having one answer will make life a lot easier than the current administrative patchwork.
So one of the other things that we want to talk about is another Supreme Court case. It deals with Abercrombie. I'm not sure how many people are aware, but Abercrombie, which also owns Hollister, they target late teens, early 20s in clothing. And so what they did is there was a 17-year-old female Muslim who applied for a job as an Abercrombie sales associate. When she applied, she was wearing a headscarf, and the person to whom she applied took the question to the manager, which is basically her headscarf doesn't comply with the look policy. Abercrombie and a lot of other brands are very brand-oriented and have very strict look policies about the way that people who interact with the public are allowed to represent the brand. And the manager determined that this applicant, her headscarf didn't comply with the look policy and didn't comport with the brand that Abercrombie has. And so even if she was wearing it for religious purposes, she could not work at Abercrombie. Now, the law prohibits discrimination based on how people practice their religion unless the employer can show that it has an undue hardship and it's unable to accommodate this practice. Now, Abercrombie argues something that really affects a lot of employers, not just those with look policies, and their argument is based on notice. And what Abercrombie is basically saying is she, the applicant, she did not say, I'm wearing this headscarf because I am Muslim and it is part of my religion. So Abercrombie is saying they weren't on notice that this was a religious expression. So they simply did not hire her because she had a headscarf on. It had nothing to do with her religion because they didn't know. So this is a really interesting question that is going to go up to the Supreme Court on February 25th. So 2 weeks from today, there's going to be the argument. And what we're anticipating is that the decision that comes out of the Supreme Court is going to be very based on this notice question. And so if you think of it even separate from a headscarf, it is, imagine that you're an employer and someone comes in and they are using a cane and they ask you, is my workspace going to be accessible by an elevator or am I going to have to use stairs? As an employer, are you really going to argue that you're not on notice that that person is asking about an elevator because they have a handicap or a disability? I mean, it really just doesn't make any sense. So this notice question is going to be interesting to see the way that the Supreme Court words it. This is actually not the first time that Abercrombie has been in trouble for their look policy. There was also a decision in 2013 that came out of the Northern District of California on very similar facts. It was a female Muslim employee who worked mostly in the stockroom. She asked if she could wear her headscarf for religious purposes, and she was allowed to so long as she wore headscarves that fit the colors of Hollister, which is where she worked, and Abercrombie obviously owns Hollister. And so she did this voluntarily, and then 3 months later she was told, no, you can't wear that anymore because it doesn't fit our look policy. It went to court. The plaintiff filed a motion for partial summary judgment, and the court granted it, saying this is an obvious violation of Title VII. and then thereafter the trial was simply limited to what damages she could receive. So basically what we're seeing is that undue hardship is not really going to be a legitimate defense in this kind of case, but what's going to be interesting is what the court says, again, about that notice piece.
The interesting thing with Abercrombie factually is that in the case, the girl who was applying, when she was interviewed by the manager, asked specifically, will I be allowed to wear this headscarf? Didn't say, you know, and it was black, and didn't say because I want to wear it for religious reasons, although as the testimony came out in the litigation, the hiring manager who interviewed her assumed it was for that reason. She takes it to her district manager, and the district manager then testifies, well, I didn't know why, apparently didn't ask, and so he's the one who makes the determination essentially and says, well, you know, you can't wear black. They have a part of the look policy for Abercrombie is no black. And so then she rates her, the hiring manager, based on the direction she receives from her manager, rates her poorly on this look issue, and that's what leads to her not being hired. The 10th Circuit accepted Abercrombie's argument that it wasn't on notice because the employee never said the words, can I wear the headscarf as an accommodation for my religion? She just said, can I wear this headscarf? And that is the issue that the Supreme Court is taking up. So what we're hoping is that the Supreme Court, to the extent it finds that explicit notice was not required in this case, it does it narrowly because a very broad decision about, you know, what an employer has to assume could be very difficult for employers to manage, both in the religious accommodation context and, depending on how broadly, potentially being used by plaintiffs' attorneys in the discrimination context as well, where we have a well-established body of case law that says, you know, an employer doesn't have to presume a disability. Obviously, there are some very extreme examples where I think it would be hard for an employer to credibly, you know, claim that they didn't know or didn't have a reason to believe that a requested accommodation was for a disability when the disability is obvious. But we are hoping that the Supreme Court, to the extent it rules against Abercrombie, which I think frankly is likely, is going to do so narrowly so that it doesn't have consequences for employers who, you know, are trying to make reasonable accommodations but not go out there and make certain assumptions.
So another case that is going up to the Supreme Court to resolve a Federal Circuit split is mock mining. This deals with whether or not the EEOC's conciliation efforts are reviewable by a court. Basically, what the EEOC says is that this is our choice, the conciliation, and courts shouldn't be able to review it. However, the law requires that the EEOC conciliate cases after having found reasonable cause that a violation occurred, and the EEOC must endeavor to eliminate discrimination by informal methods of conference, conciliation, and persuasion. Now, the 2nd, 4th, 5th, 6th, 8th, and 9th circuits have all said, yes, to some extent, the EEOC's conciliation efforts are reviewable because they're required to do so under law. Now, the 2nd Circuit has said that the EEOC's conciliation efforts are not reviewable at all. So the argument went up to the Supreme Court on January 13th. We're waiting for the decision on that. As you can imagine, there is a little bit of dissension among the justices as to what's going to happen. Justice Scalia, during oral argument, he stated that there's considerable incentive for the EEOC to fail in conciliation so that they can bring big deal lawsuits and get a lot of press and put a lot of pressure on this employer and other employers, whereas other justices saw the challenging of good faith conciliation efforts as a legal strategy by employers meant to prolong the process and to really shift attention away from the actual discrimination that's at issue and instead attack the process. Finally, in discrimination and protected classes, there has been some OFCCP discrimination proposed rulemaking. It happened quite recently. The comment period ends March 31st. They're really seeking to update the rules prohibiting sex discrimination by federal contractors and subcontractors. Now, the proposals, you can read the proposals that are on the slide, and also they include prohibiting harassment and hostile work environment, and also prohibiting decisions that are based on sex-based stereotypes, like we were talking about before, that sexual orientation is somewhat protected because of those sex-based stereotypes. The proposed rules also kind of reorganize what are now called guidelines and what will soon be called rules, because apparently the EOC or the OFCCP says that guidelines, that's not a strong enough word. Rules will really, punch it up for employers. You have to comply. And what we're hoping is that this reorganization and this more specification is going to make it easier for employers to comply with the law, maybe not have to come to us as often for some sort of interpretation of the law, but we'll see after the comment period ends and they finally give us a final rule. And I'm going to now turn it over to Shannon to talk about employee leave and accommodation.
Thanks. So one of the reasons we may be seeing the OFCCP looking to make it rules as opposed to guidelines is in a number of areas we're seeing the courts refusing to give the same kind of deference to government agency guidance that they're giving to rulemaking, and that relates to whether it really went to the procedures of the Administrative Procedures Act and other things. So I think there's a number of areas where the agencies have been getting pressure from the courts to do more formal rulemaking. And in fact, there's a case that we're going to talk about in a minute that's before the Supreme Court that relates to whether agencies can basically flip-flop on their rules through guidance. So I think that's part of the reason we're seeing that happening. Okay, in the issue of leave and accommodation, this year's big theme is pregnancy. Pregnancy accommodation is the hot topic, as we'll see in a number of different areas, both federal and state. The EEOC in July issued a guidance, and that is, I think, significant here, about the Pregnancy Discrimination Act. The Pregnancy Discrimination Act, a many years old amendment to Title VII that prohibits specifically discrimination on the basis of pregnancy. It's been around for decades. It's been well interpreted. But now the EEOC has looked explicitly to expand it by trying to expand the scope of it. And I think one of the most significant ways that it has done that is through this issue of accommodating pregnancy-related limitations. And I won't call them disabilities because in most cases, pregnancy itself there's no question, pregnancy itself is not a disability under the ADA. Before the ADA Amendments Act, we would have said even pregnancy-related complications that exist only during pregnancy are not disabilities under the ADA because of their temporary nature. While pregnancy may feel like it lasts forever, it has a finite end, and so therefore not going to be a disability under the ADA, which does not cover temporary conditions. However, with the ADA Amendments Act, we're seeing that pushed. And in fact, in this guidance, the EEOC is saying, well, okay, pregnancy isn't, but pregnancy complications can be, without really addressing this issue of temporal limitation. So if somebody is on bed rest for 2 days, is that now a disability? And those are questions, I think, still to be fleshed out. But the other significant issue here, and I think the biggest practical issue, both with the EEOC guidance, and there's a Supreme Court case I'm going to talk about in a second, is this issue of affirmatively giving people light duty. Many employers have policies that say we only do light duty for work-related injuries. The EEOC says, no, you can't do that. It takes language that says you have to treat pregnant employees basically on the same basis as employees who are similarly situated in their inability to work, and says, well, that means that if you offer light duty at all to anybody, you have to offer it to pregnant employees. But my question about this is, how is somebody who is pregnant similarly situated to somebody with a work-related injury? Pregnancy is not a work-related condition. We hope, or we have a whole other thing to talk about, but it's not the same thing. I mean, we're not making a distinction based on the pregnancy, lack of pregnancy. It's a totally pregnancy-neutral distinction, and yet the EEOC is saying, if you offer light duty, you have to give it to pregnant women. That is clearly an expansion of the view of the law that has existed for decades. And so that's going to be a big question. Now, it may, in fact, this EEOC guidance be irrelevant because we have a case pending before the U.S. Supreme Court that is not based on the EEOC guidance, it existed, Kim's about before that it really raises the exact same issue, and that's Young versus UPS. We had an employee who was a driver. It required heavy lifting, 70 pounds. She became pregnant. Her doctor said, you can't lift more than 20 pounds. And UPS said, we don't offer that kind of light duty in your position. We only have it for work-related injuries. So she took an unpaid leave of absence. She'd already exhausted her FMLA. They did not terminate her. They just said, take unpaid leave because you can't do the job. She sued, alleging gender and disability discrimination. The Fourth Circuit said, pregnancy is not a disability, and this is not a violation of the PDA to limit light duty assignments to non-pregnant employees, you know, if you're doing it on the same basis that you would for any other non-work-related disability. So this is now before the U.S. Supreme Court. The justices, I think, at oral argument, which was held a few weeks ago, really, from all commentators, appeared to be struggling with this. And really, instead of just, they were dealing with this question of compared to whom, because the Pregnancy Discrimination Act says that you can't discriminate, but compared to whom is what they're struggling with. Is it anybody in the workplace? Is it anybody who has a non-work-related limitation? And so what we heard at oral argument was the justices really trying to get into the facts. So it's going to be interesting to see. There's some speculation that what they're going to do is send it down for more development of the record. Interestingly, UPS, although this case was not settled and continues to be pending, UPS has since changed its policy and is now offering accommodation of pregnancy affirmatively. So we should get guidance on this. This will be decided this term, so keep your eye out. We'll know by June what the requirements are. But even in the absence of that, what we're also seeing is state and local governments taking on this issue and enhancing protections for pregnancy. So the New Jersey law against discrimination was amended in 2014 to add pregnancy and create a reasonable accommodation requirement. Similarly, the Philadelphia Fair Practices Ordinance was amended around the same time to do the same thing. And Philadelphia also has a breastfeeding ordinance which requires specific accommodation for lactation and that areas be provided. This is similar in some ways to the requirements that were, I think, sort of a hidden part of all the healthcare regulations that were also required breastfeeding accommodation, although these go a little bit further. So keep that in mind if you have lactating employees, that there is an obligation now, both in Philadelphia and nationally, at least some extent, to accommodate that. And the exact details of that in terms of whether you have to affirmatively provide a place or you just have to give break time, how you have to do it, are going to depend on location. Paid sick leave is another hot area around the country. So there's been proposals at a federal level that the president has talked about this as being an important issue for middle-class workers. But we've also seen a lot of legislation, I should say, of this at the local level and the state level. Here in Philadelphia, there was a bill that was vetoed by the mayor in 2008, and as a compromise, there was a task force that was created on the issue of paid sick leave, which issued its report towards the end of 2014 and made certain recommendations. And although this a new ordinance has not yet been enacted, the mayor has indicated that he would sign something along the lines of the task force. So we can expect to see that coming in Philadelphia at some point. Next area we're going to talk about is some wage and hour updates, everybody's favorite topic, wage and hour. It continues to be a very hot area of the law. We're going to talk about just a couple of significant pending cases. One recent decision in December of 2014 was the unanimous, and we don't say that very often, U.S. Supreme Court decision in Integrity Staffing Solutions, which dealt with security checks for Amazon employees and whether people had to be paid for the time going through these security checks. The court said no. This was really consistent with, I think, as you can see from the fact that it was a unanimous decision, a large body of case law that has developed over the past 60 or so years involving what is, and the term is integral and indispensable to the primary activity that the person is hired for. So you have to pay people for their activities, their primary activities, but you also have to pay for those things that are integral and indispensable activities, and the timing of when things occur often matters. So there's been a lot of litigation over the years about things like changing clothes. A lot of these come out of meat packing and poultry packing industries because there's a lot of specialized clothing for sanitary purposes, some kinds of manufacturing. And also we see it with tools and equipment. You can see the examples on the slide. So for example, people having to sharpen their knives. The idea is you can't do your job without the sharp knife, therefore it's integral and indispensable. If you have to wear certain safety equipment because you can't do your job without it, it's integral and indispensable, as opposed to equipment that may be required, for example, for the employee's convenience. The other factor that courts look at often is this equipment, is this security line, whatever it is, something that is specific to the job, or is it something that anybody who's going into that area is going to go through? So when we're talking about security checks and things like that, typically the courts have said, look, anybody who's going into that area has to go through it. It's not specific to the job. So this Amazon case, very similar to cases that we had seen out of the circuit courts for things like nuclear power, plants where people have to go through radiation checks or things like that. If we went to the plant, we'd have to go through the same check. Therefore, the court's thinking is it can't be integral to the job of the worker because anybody who's going there. And this follows along those. So while it puts that to rest, it's a nice reassurance for employers that they don't have to go and significantly revise these policies. It was not a major departure. In what was a significant departure, the New Jersey Supreme Court in January of this year issued a decision that changed the test for how you determine whether somebody is an employee or an independent contractor under state law. It adopted, excuse me, what is generally referred to as the ABC test. And you can see the details of it on the slide, but this is more restrictive generally than the test that, for example, the IRS uses. In this issue of employee versus independent contractor, we have a very difficult situation for employers because depending on the context in which you are asking the question, the test is going to be different, and it can result in different answers. So you could have somebody who is an independent contractor for tax purposes under federal law, but may not be an independent contractor for other issues now under state law. This ABC test is one that has been used for years in Pennsylvania for unemployment compensation and for workers' compensation. So we've already had that situation in Pennsylvania, although it has not necessarily been true in the wage and hour context. So very difficult. Oftentimes the advice to employers is going to be, follow the most restrictive test, look at this conservatively because of the risk and because it is something where there is a lot of shifting landscape and because the consequences when it comes to employee versus independent contractor can be so severe. In the tax consequence, you can have penalties and fees. If we're talking about denial of benefits, you could have back benefits issues. If we're talking about wage and hour, you can owe overtime. So there's a lot of consequences. So often we're going to be looking at what's the most restrictive test that's likely to be applied, and let's make sure that you can meet that. The FLSA exemptions is an area where I mentioned that we're waiting for Department of Labor to issue regulations. So In March of last year, the President directed the Department of Labor to modernize and streamline the regulations relating to the white-collar exemptions. The goal here is to narrow those exemptions so that more people will receive overtime. That's obviously a concern to employers, and also expected to raise the salary requirement in addition to changing the duty steps. So this was originally, when it was done, said, okay, we're going to get these in December. Obviously, that didn't happen. So there was some speculation. Originally, the date was supposed to be earlier in 2014. People said, okay, it's going to be after the election. That's why the December date. The latest we have heard, sort of unofficially, is maybe February, but we're now sitting here on February 11th, and there's been nothing more specific of that, so we don't really know why. But we would expect that we're going to have the salary range. There was a proposal that was just made by some economists that said if you really want to do this, you should be raising it to $50,000 a year. That would essentially double it. Right now, it's, if you do the math, it's somewhere in the mid-20s. And so that would essentially double it. That would affect a huge number of employees who are now considered to be exempt in sort of lower wage occupations. We also expect that they may try to do something with the primary duty test. In the regulations before 2004, which is the last time they were adopted, there was what's called the short test and the long test. Well, nobody ever had to follow the long test because of the salary threshold, but under the long test, there was actually a revision that you had to spend at least 50% of your time. They've moved away from that in the 2004, and in fact, in the intro to those regulations, to the preamble, they said it's not a percentage of time. So now we may see a shift back to that because commentators, some believe that the Department of Labor believes that employers are taking advantage of that and trying to have people who spend very small amounts of time do it, and that supported by some court cases, particularly in the area of like retail management, where people who maybe, take the example of a Starbucks manager, they may spend a lot of time on the line, but courts in some cases, this has been an area where it's very fact specific, have said, well, but still for the manager, the primary duty is still management because they're accountable. So even though they may spend in any given week, 30 hours working the line because you're short staffed, because you're whatever, that doesn't mean that they're not still a manager. So we may see a percentage in there as well. The other reason that we're going to see this change from the Department of Labor is because of cases like the Mortgage Bankers Association case. Basically, in the 2004 regulations, the Department of Labor gave examples, particularly in the administrative exemption, because that's the one where a lot of this comes, that they listed mortgage loan officers as an example of an exempt profession. Well, times change. In litigation since then, 2010 specifically, they said, no, they're not exempt. They didn't amend their rules. They just basically took a different position in litigation than they had taken in the rule interpreting their own regulations and the statute. Courts have said, you don't get to flip-flop like that. And so the Supreme Court has actually taken this question of whether a federal agency can actually do formal notice and rulemaking before it changes its interpretation of its own regulations. So that's another significant Supreme Court decision. We're going to see this. We could also see this have an effect, depending on how broadly the court rules, on the NLRB, which often changes its own interpretation of the law as well. So that's another area this could have a significant case. Something closer to home, the Walmart case, and you may remember this from a number of years ago, there was a huge verdict on a really large class of workers for missed rest breaks. The significance of the Walmart case, and the reason why we're talking about it now, is that recently the Pennsylvania Supreme Court upheld the verdict. This $150 million was the final, after the courts had done some things with it, but upheld it. And the significance of this is the Pennsylvania Supreme Court accepted the statistical evidence, because Walmart said, no, you basically let us be tried by formula. And I think it is clear from this that the Pennsylvania Supreme Court has taken a more expansive view of the way you can prove class actions than we've seen from the U.S. Supreme Court in more recent decisions, including, for example, the Walmart sex discrimination case where the U.S. Supreme Court said, no, you can't do this by sampling, and it's just not workable. Here, in this context with a wage and hour, they let the plaintiffs do that in 187,000 person class action. So what we may see is Pennsylvania courts, which have traditionally been pretty quiet in the area of state wage and hour litigation, unlike, let's say, California, which is a hotbed of it, we may, in fact, see a lot more of these cases being filed in Pennsylvania state court under the state wage and hour laws, both the Minimum Wage Act and the Wage Payment and Collection Law. So for practitioners in Pennsylvania, everybody needs to be really thinking about Pennsylvania because it is a trap for the unwary, as we've seen in some specific areas where Pennsylvania Minimum Wage Act does not mirror the Department of Labor under the Fair Labor Standards Act, and particularly as it has been interpreted by the U.S. Department of Labor in the regulations. So if we see an expansion of litigation in Pennsylvania, there could be places, not only are we going to be, in the Pennsylvania courts, which are now more employee-friendly in terms of permitting class actions, but substantive areas where employers may be caught because the exemptions don't exist, and I'll give you an example. Under federal law, there is a specific exemption that says teachers, doctors, and lawyers who are practicing those professions don't have to be paid on a salary basis. So contract lawyers, for example, you can pay them hourly. They're still exempt. There's no similar exemption under Pennsylvania law. Never seen it litigated. That may change. We've seen some of those other areas where Pennsylvania doesn't have similar rules being challenged. An example in healthcare, there was the 8 and 80 rule, permits overtime to be paid differently than just on a normal 40-hour. There was litigation. The court said, hey, you're right. You know what? That's not permitted by Pennsylvania law. And the Pennsylvania legislature, lobbied by the healthcare industry, hospital association, such, immediately amended the Pennsylvania statute to get rid of that because it would have been crippling for hospitals to pay that way. But there's still an issue about the cases that were filed before the law changed. There's cases out there right now related to, for example, what's called fluctuating work week, which is a method of paying overtime, again, different from the normal regular rate, time and a half, and the courts have been unanimous saying Pennsylvania doesn't recognize it. So there are some very savvy plaintiff lawyers who are exploiting those areas. I think we're going to see more of it now as Pennsylvania becomes an even more friendly plaintiff state. Intern litigation. This has been another area of a lot of cases being filed. So the first 2 of these that are going to really get the full hearing in the court, there was oral argument before the Second Circuit just recently, a few weeks ago, and from reports that I have read of the oral argument, it was clear that the judges were suspicious of this, what's called 6-factor test that the Department of Labor has. The Department of Labor takes the position that, takes the position that in order for somebody to legitimately be an unpaid intern, you have to hit all 6 of these factors. And so that if somebody is doing basically any work that would otherwise have been done by an employee, they have to be paid as an intern. And that's where most of these cases have been hanging up. Was clear from this that the justices were somewhat skeptical of this and instead appeared to be favoring what is known as the primary benefit test, which looks at for whom the primary benefit exists in this relationship. Is the intern getting more out of it, of the experience, or is the employer getting more sort of substance and beneficial work? So it's a balancing test. And you heard the judges sort of saying, look, judges like balancing tests. We don't really like rigid factors. One of the more interesting things, though, is that at oral argument, counsel for the Department of Labor conceded that the 6-factor test is not always rigid and does not have to be strictly followed in all situations, which is considered to be a big admission. So we're going to see what comes out of that. But to the extent that the Second Circuit says it's the primary benefit test, not the 6-factor test, and that is more widely accepted, we may see this intern litigation calm down. In the meantime, everybody should be looking very carefully at their intern program. if they are working for a for-profit. Nonprofit is a different calculus because you can actually have volunteers, although we still need to talk through whether they're getting anything of value. And with that, I'm going to turn it over to Elisa to talk about some healthcare issues.
Great, thank you. So just a quick review of some of the major healthcare issues, health benefits issues that have come out in the last year. So the first would be the Hobby Lobby decision, which I'm sure most people have heard about. Just to recap, the Hobby Lobby case challenged the Affordable Care Act requirement that employer-sponsored group health plans must provide preventive care and screenings without employee cost sharing. So that includes various methods of contraception for women and at no cost to the employee. So there were several organizations that challenged this and alleged that it was a violation of the Religious Freedom Restoration Act, saying that, that it was against their religious beliefs to provide this type of contraception. In particular, there were 4 types that are considered abortifacient drugs. So the Religious Freedom and Restoration Act specifically provides that the government cannot take action that substantially burdens the exercise of religion unless it's in furtherance of a compelling interest and uses the least restrictive means to do so. So the court looked at this, and basically it said that it sort of skirted the issue of the compelling interest and said, we don't really need to litigate whether, the government has a compelling interest in providing contraceptive coverage at no cost to the employee. But they really closely examined this concept of the exercise of religion and whether these privately held corporations could be considered as entities that can exercise religion, and then also whether it was the least restrictive means, the government's interest was achieved by the least restrictive means possible. So what the Supreme Court held that these organizations, although private companies were closely held, and that because they had sincere religious beliefs against the provision of this coverage, that they are protected by the Religious Freedom and Restoration Act, and that they could not be forced to provide contraceptive coverage to their employees without cost. The court took some time to really talk about this least restrictive means idea, and that and actually identify other ways in which the court thought that this coverage could have been provided to employees that would not have burdened the religious interests of the employer of Hobby Lobby in this case. So I think one of the big things about this is that it leaves the door open in some ways, because there's not really a specific, there's not a bright line drawn between what makes a corporation have sincere religious beliefs. It does identify closely held as being, as a closely held corporation as being protected by the Religious Freedom Act, and as you can see on the slide, 9 out of 10 corporations are classified as closely held and employ approximately 52% of Americans. So that could have huge implications going forward as far as the reach of this decision and how many employers it's actually going to affect. And how many can seek protection under this ruling. So it remains to be seen, and I think that will be interesting in the coming year. The next case that came out was fairly recently, and that was the M&G Polymers v. Tackett case relating to retiree medical benefits. This was a case where the employer and respondent union had a collective bargaining agreement, as we often see, that provided for retiree health benefits for retired employees, spouses, and dependents. And it provided that the employer would pay the cost of coverage, and the specific language was for the duration of the agreement. And the agreement was on a 3-year renegotiation schedule. The employer paid, I think it was about two contract terms, so I think it was approximately 6 years, where they continued to provide this employer contribution for the full cost of retiree medical coverage. And then at the next turn in negotiations, it was, when that contract expired, they said, we're no longer going to make that contribution. Retired employees have to pay for their retiree coverage on their own.
at which point those employees brought suit, and they, relying on the fact, on the argument that they had a vested right to this retiree health coverage indefinitely. The Sixth Circuit looked at this case and, relying on a long-established holding in the Yardman case, which some of you may be familiar with, said, you're right, you have a vested right to this benefit indefinitely, and they can't take this away from you. This went up to the Supreme Court, and it's actually very interesting that the Supreme Court looked at Yardman, which has been around since the 80s, I think, and said that it did not correctly apply the principles of contract law to that holding, and therefore essentially strikes down Yardman and its progeny is all affected by this Supreme Court's case, the Supreme Court's holding in this case. So they spent a lot of time kind of taking apart Yardman and saying that in looking at it under the ordinary principles of contract law, they misconstrued things. So, for example, in the Yardman case, the court inferred that because there were certain elements of the collective bargaining agreement that specifically provided for termination of certain benefits, the fact that there was no provision for the termination of the retiree benefits essentially created a presumption that there was no termination of the retiree medical benefits. So this is why typically, we advise that clients always put a clear termination, a right to terminate the retiree medical coverage in a CBA, but a lot of that is based on this Yardman presumption that had previously existed that's now been struck down. So we would still recommend that you continue to include specific termination provisions in your CBAs, but it's interesting that that's kind of gone out the window at this point with this decision. So the Supreme Court comes down in M&G Polymers and says that Yardman basically places a thumb on the scale in favor of vested retiree benefits, which is a presumption that we've all kind of worked under for quite some time, and now it's a little bit more of a level playing field in that the Supreme Court has said you have to look at the intention of the contract, the different provisions of the contract that might affect retiree medical benefits and what you've agreed to, and not just working under this presumption that retiree medical benefits would vest unless otherwise explicitly stated. The next would be Affordable Care Act reporting. Some of you may have seen this week that the final forms for 2014 were published. Sections 6055 and 6066 were added to the Affordable Care Act to require reporting of minimum essential coverage that's offered by employers. This is basically the way that they're going to sort of check to make sure that employers are offering coverage and that employees are taking advantage of coverage. It serves two purposes, really: the employer shared responsibility payments, and then also the individual mandate to make sure that people are correctly reporting the coverage that they've been offered by their employers. So the first reporting, and this will apply to all employers, all large employers, the first reporting is required by February 29th of 2016 if you're going to file by paper, and March 31st of 2016 if you're going to file electronically. It's important to note that if you have more than 250 employees, you're going to have to file 250 forms, and you're required to do that electronically. So there is a threshold at which you cannot choose to file by paper. You have to file electronically. Which benefits, I think, in the long run because you have an extra month to do it. In any event, reporting for the 2014 year, you may have heard some people discussing this. It's optional this year to have, in 2015, to report for the 2014 calendar year. Some employers have chosen to do this. Again, there's no real benefit to it other than just trying to familiarize yourself with the forms. That said, the forms that were published are 2014 forms, and there's nothing to say that they won't change again for 2015. So in some ways, I think it makes sense to review the form, familiarize the information that you're going to need to have next year, but don't actually put yourself through the torture of trying to figure out how to do that reporting for 2014. So if you are going to file, the form is going to look somewhat like this. And again, I don't expect this to change tremendously in 2015, for the 2015 year. So you can see that the form is pretty consistent with what was expected based on the instructions which were released last year and the regulations on this reporting that were released last year. That said, it does require a certain amount of detail, and this 1095-C is what would be required of applicable large employers, that's 50 or more employees, and you would need to fill out one of these for each employee, full-time employee that you have. So that includes the name, social security number. If you don't have that, there are other options and numbers you can use. And then the chart, the two charts below are essentially representative of, you would have to indicate whether you offered minimum essential coverage to the employee for each month of the year and how much that cost for the employee. So it's a lot of information. And then in addition to that, if you are a large employer and you have a self-insured plan, you would need to fill out one of these 1095-Cs for every employee that gets coverage under your plan without regard to whether they're full-time or not. So it's a lot, and if you are, a really large organization, you probably have employees that fall into different categories. You have to calculate hours to determine whether people are full-time or not. So there's a lot of moving parts to this. Again, the deadline is for 2015 will be end of February of 2016 or end of March of 2016. That seems like a long time, but I think starting to prepare for that now and making sure that your payroll providers or any third party that you work with to help you collect this information in a systematic way that's efficient, it might be good to start looking into that now and making sure that you're prepared for this reporting for next year. There are two forms, essentially, the 1095B and the 1095B and 1095C. The 1094s are the transmittal forms, so you can sort of disregard that. That's basically going to be like a cover sheet almost that goes on top of each form. But in any event, these are the two forms. You'll probably hear a lot about these over the coming year, and this is what you want to have your sights on to be prepared to file in early 2016. And unlike some of the other provisions of the Affordable Care Act that kept getting delayed, and we don't expect that this will be delayed any further than 2016. So for those of you holding out hope that it might go away for another year, don't hold your breath. Okay, the next thing I wanted to go over is the Anthem data breach, which some of you may have heard about in the news. Last week, there was a pretty sophisticated cyber attack on Anthem, which I think they cover a number of different health insurers, Blue Cross being one of them. And the early reports indicate that it could have affected 80 million plus current and former customers. And the breach did include protected health information as well as just personally identifiable information. So in general, I think Anthem has certainly stepped up and indicated that they're going to do anything and everything they can to mitigate the damages here. But I think this is an important reminder for all employers about the importance of having your HIPAA business associate agreements buttoned up and in place. So that because in a situation like this, there are very specific notice and disclosure obligations to all the individuals affected by the breach, all 80 plus million. So, in general, if the employers that have Anthem as their insurer, where they're sort of really hands-off, and Anthem kind of processes all the information. Anthem definitely has more responsibility in that case, and typically the business associate agreement is set up such that in the event of a breach, it's really on Anthem to meet these obligations and to cooperate with the employers whose individuals it affects. That, however, on the other hand, if you have Anthem acting as more of a third-party administrator, the health plan has far more responsibility under the HIPAA rules to be, proactive and reactive to this issue, and to get out there and make the notice and disclosures to the affected individuals. So I think this is the kind of thing that you hope never happens, but when it does, you have to look very closely at your business associate agreements to understand who has an obligation to do what. So under HIPAA, there are required notices within 60 days of the discovery of the breach. I believe that Anthem has already stepped forward and said that they would be supplying those notices, but depending on how the business associate agreement is drafted, that could have been something that was put on the employer or the plan to provide those notices. There's also required notices to federal authorities and media outlets. There are requirements to set up basically call lines so that affected individuals could contact Anthem and say, hey, was my information, what information of mine was compromised? What are you doing about it? And all of these things have costs associated with them. The estimates are that it's $100 to $230 per individual in costs for these kind of response requirements, which is huge. And not to mention the legal costs that may be generated from this as far as class actions and things like that. So this is, I think, a very important reminder of, why you need to have your business associate agreement in place, and why you need to know what you're agreeing to when you're doing it, so that in the event of something like this, you're not stuck, holding the bag, in addition to the liability concerns. In this case, I think that, again, Anthem has pretty much stepped forward, but you just, maybe in something less high profile, you could find yourself in a situation where, your D&O insurance policy may not cover, certain actions or of the company. I mean, I think it just depends on each agreement, so that's why it's important that each business associate agreement be reviewed individually.
Just another thing, when you're working on contracts with third-party groups, the one thing they always push back on is that they will pay penalties up to a limit, and generally they keep that limit as low as they can. And when you look at some of the penalties as a result of that, it's much higher than that. So we always get a lot of pushback from parties saying we'll only pay up to a certain amount. We want to say, no, you've got to pay whatever it is that comes down, and that's where a lot of argument comes back and forth.
Yeah, that's a great point. The civil monetary penalties and things in these circumstances can be very, very high. So it's something that, I think now is as good a time as any to make sure that you have your business associate agreements buttoned up the way they need to be.
So I'm going to talk quickly about technology in the workplace. One of the large cases that came out in the past year about technology in the workplace has to do with a combination of technology and accommodation. This was a case out of the Sixth Circuit where an employee at Ford who was involved in resale steel buying, she suffered from irritable bowel syndrome, and she requested as a reasonable accommodation that she be allowed to telecommute up to 4 days a week. What the company argued was that face-to-face interaction was an integral part of her job, and that telecommuting 4 days a week is not going to be a reasonable accommodation. The important take-home from this case was that the court refused to defer to that employer's determination regarding the importance of her actually being there, and instead really took the employee's impression of how important it was for her to be at the workplace as their determining factor. So that is one of the very important things to remember. The EEOC and courts are really looking at workplace as not, you know, an office that people report to anymore due to telecommuting capabilities, as well as email and conference calls and things like that. So what the important thing for everyone, even just all employers in general, is to look at your policies and make sure that you do not have a policy that says that telecommuting is not going to be available or, you know, is an undue hardship for the company. The EEOC has said that a blanket requirement like that is not going to be acceptable, and that you really need to work with employees on an individual basis about what kind of accommodations you can offer them, and just keep thinking back to the fact that the EEOC and the court really accepted what the employee thought was important to her job rather than what the employer thought was important to that employee's job. So the next thing that I'm going to talk about is searching electronic devices. Really quickly, there were two important decisions recently about the expectation of privacy in cell phones. These two cases were not in the employment context, but as you'll see, they do have implications for the employment context. One was Riley v. California. That was a case in which the individual was arrested on a weapons charge. The police searched him and seized a smartphone out of his pocket. The smartphone contained photographs and videos that they then used to link that individual to an earlier shooting. The other case is Retiree, I believe is how it's pronounced. This person was arrested after he made a drug sale. During the search, the officer seized 2 of his cell phones. They used it to link him back to his home address. They executed warrants, searched his apartment or residence, and they found drugs and weapons and brought charges against him for those. What the U.S. Supreme Court has said is that there is an extremely high expectation of privacy in a person's cell phone. These cell phones often contain the sum of an individual's private life. I think we can all completely agree with that, or at least I know I can. It's not even private life, it's also work emails and things like that. So there's a great expectation of privacy. And so the important part for this is a case where this was actually applied in the employment context. This was a case out of Connecticut where the employee was alleging race discrimination and hostile work environment. As part of discovery, this person wanted to take the other employees' cell phones and really examine them and see what kind of information was on there about possible harassment and discrimination. And basically what the federal court said is that the expectation of privacy in cell phones is so high that we're really not going to allow you to just take people's cell phones, look at them for information that you think might be there, and, you know, kind of go almost on a witch hunt type of thing. And I think actually what ended up happening in this case is the court really narrowed it to that the employer had to provide the emails that were on the employer's server that were sent back and forth using text or cell phones, but not the cell phones themselves. The other important thing to remember about expectation of privacy in email and, you know, employers searching employees' computers and things like that is the Stored Communications Act. The Stored Communications Act is part of the Electronic Communications Privacy Act. The Stored Communications Act brought email under the same types of under the same protections that are offered by the Wiretap Act, what we traditionally think of as tapping a phone. So the important thing to remember here is that employers cannot intercept emails. So if an email is coming in, you can't look at it as it's coming in or as it's going out. That's interception. However, there is an exception where employers may look at an employee's emails, especially that are served or stored on the employer's servers. So this is a really important point, is that employers that offer the capability, the wireless networks, things like that, they are a service provider, and an exception under the Act says that service providers can look at this kind of information. Now, this does not mean that if an employee is still signed in on their computer to one of their personal accounts, such as Gmail or Yahoo, that the employer can go and look through the employee's Gmail account. They cannot do that. However, if for some reason one of those messages is stored on the employer's hard drive, a lot of times it's called the residual space of a hard drive, the employer can look at that. So that's really just something to keep in mind, that you need to be careful exactly what you're looking at.
I.e., talk to your tech people and your lawyer before you go try and search any employee emails at this point.
So the final thing I'm going to talk about in technology is social media laws. There are now 19 states that in the past few years have enacted laws which prohibit employers from asking either applicants or employees what their passwords are to their Facebook or other social media accounts. Pretty much just don't do it. It's very simple, even if you're in a state that allows it. There's a big trend, and it's likely that your state is going to follow suit soon.
Okay, the next thing that we're going to talk about is what's going on at the NLRB. Now, if you are a private sector employer, i.e. non-governmental, and you do not have unions, you may think, I don't care, but the fact is that you do care, because the NLRB is actually spending most of its energy these days on non-union employers, and that's where a lot of its efforts are really being directed at issues of organizing and helping organizing take place. So the first thing that we're going to talk about is the recently issued ambush election rules. They were issued in December. They take effect in April. And if any of you remember the discussion surrounding the proposed Employee Free Choice Act and discussions about how much easier that was going to make organizing, the ambush election rules I like to think of as EFCA-lite. So they make the organizing piece of it simpler. The thing that they do not do is have this idea that there's this automatic card check. There is still an election, and I think that this is a reaction to the fact, one, it's not within the power of the NLRB to do this without Congress, and Congress made pretty clear they weren't going to pass something that took away the right to a vote. So what they do is speed up the process considerably. It is widely believed that they are being passed so that it will be harder for employers to challenge elections. For example, a lot of types of litigation challenges that more employers might bring are put off till after the election. The whole push is get to an election quickly, and that way employers have less time to gear up and to campaign. So there are two legal challenges pending, one filed by the Chamber of Commerce, the other by another group in Texas. Slightly different takes. They challenge both them as being outside the authority of the board as rulemaking, that these challenges are inconsistent with the National Labor Relations Act, which is not actually supposed to be for the purpose of enhancing unionization, although that's the NLRB's current view of it. And they also deal with whether or not it's a violation of the impedes First Amendment rights by limiting employers' ability to speak to their employees. The Chamber of Commerce, in their case, filed a motion for summary judgment this week, asking to have the rules held invalid. We still have some time to see whether they ever go into effect, but for those employers who might be affected, that is, if you have employees who could be unionized in the private sector, it's the time now to get ready to do an assessment of your vulnerability, to look at things like what would you do if there was a campaign tomorrow and you weren't really going to have time to respond. So thinking about your campaign, thinking about who are statutory supervisors, doing training, all of those kinds of things. So this is an area where if you think you have some vulnerability, you should be talking to counsel about what you need to do to get ready, because you will not have time if they go into effect in April. The other big NLRB news of the recent weeks is the Purple Communications decision. So in 2007, the NLRB issued a decision called Register Guard, which said that the union does not have the right to access employer emails to send out communications to its employees. In just a few weeks ago, the NLRB changed that view, overruled Register Guard, and said, nope, we didn't mean it. In fact, if you give employees access to your email system, you have to let them use it for non-work related reasons, including sending out union materials. So this is an expansion of the traditional rules involving solicitation of and distribution that have long been in place, but basically they say you can use the employer's email system. They rejected the idea that employers' privacy rights and employers' rights to control its property should trump, and basically said email's too important a means of communication, you can't limit it, you may be able to limit it, for example, to work-related. It also says that you can rebut the presumption that employees should be able to use this email during non-working time by demonstrating the existence of special circumstances. We don't know what those are, but we expected that would be read very narrowly by the board, and it also affects the employer's ability to monitor email communications. So people should be looking at their policies where they say we can monitor your emails all the time. You can't monitor employee protected activity, so this limits, as a practical matter, employers' ability to monitor email communications. So that's an area where employers should be looking. Okay. Another issue as it relates to distribution of material, you can see this is really in this ALJ decision, Mercedes-Benz, looking in part of a trend of the NLRB looking very carefully at employer policies, often of non-union employers, but union as well, in handbooks that it believes has any potential, and potential here, not actual, to chill employees' exercise of their rights to join together for their mutual aid and protection, which is what we mean by saying their Section 7 rights. So looking very closely at policies and things that relate to where and when very closely at this. This is an example of it. It's not the only one. Similarly, the recent decision involving recording of workplace conversations. In this instance, we saw there was a work rule prohibited recording of conversations without prior approval. And in this case, one of the very few, the board found that the rule was lawful because it didn't prohibit protected activity. There was nothing by just prohibiting the recording of conversations, and it didn't prohibit the employees from having the conversations, and there was no evidence that the rule was aimed at union activity. But the key here is it didn't limit the kind of conversations that people could have, whereas these other situations, the board is concerned about people being chilled in their ability to have the conversation. And in fact, I think there's some question that, if somebody was allowed to record the conversation, it could actually chill people's ability. If you think there might be a mole who's recording you, people might feel more concerned about their ability to speak freely. Social media has been, Social media has been a big issue for the NLRB, trying to get at where to draw the line between what an employer can do about social media activity by employees. The NLRB's view as expressed by its chairman, is it's just trying to keep its traditional rules up to date with changing technology, saying that it applies the same standards to work-related speech in social media as it applies to traditional forms of communication, and it's referred to as social media is the new water cooler. The difference is for employers, people don't view it that way, right? So if you heard that two employees were having a conversation at a bar off duty, or if at a water cooler on a break, employers would not often view that statement the same way they do as if they find out that somebody posted it on a social media site where it may be seen by hundreds or even thousands of people. And that's the difference. So when I have conversations with employers who will say, somebody just told me that so-and-so posted this on their Facebook page. And I said, if you found out that they said the exact same thing sitting at a bar on a Friday night, would you feel like you had the right to fire them? Then you probably don't have the right to fire them right now. But people don't feel that way about it. So it's an emotional reaction by employers because they're more concerned about the impact on their business, impact on other employers, their image online, all of those things. So it is a very difficult line for employers to do. One of the interesting things that's come out of the NLRB is what is protected activity, and the NLRB has taken the position that liking somebody else's post is protected activity, so that it cannot be the subject of discipline. So you have somebody, maybe a former employee, who posts a critical comment, and all the current employees do is like it, discipline for it, and the NLRB says, nope, you can't do that, that liking it is protected activity. In another example of the NLRB taking on employer policies, in this hospital case, the board looked at an employer policy that said people would not make negative comments about fellow team members, and to represent the hospital in the community as a positive and professional manner, and will not engage in or listen to negativity or gossip. Now, we can talk about whether such a view of, sort of a Pollyanna view of what people are going to do with their time is realistic as an employer, but the board found that these phrases were overly broad and would discourage employees from exercising their Section 7 rights, because in fact, when you're talking about protected concerted activity, which could be trying to unionize, you often would make statements that might be negative about the employer, or even about other employees, and that is protected activity. So even though this was drafted by management and employees together, not a union, but employees, it was found to be unlawful. And again, this is not about somebody who was disciplined for it. This is facially unlawful. The board has been taking on these policies, not just the consequences. Two other examples where the board found unlawful, a policy said that postings that have the potential to have a negative impact on the company may result in disciplinary action, and employees should write and post respectfully. Clearly, that's, I think, not even a close question within the board's jurisprudence, but just saying something that could have a negative impact on the company. You know, unfortunately, while employers would like to be able to protect their social media profile and their public profile more than that, the board is not going to allow such broad policies. And another one that required workers to use a specific disclaimer if they identified themselves as working for the company or published any work-related information online. The really interesting thing about this is that the administrative law judge working for the NLRB disregarded the company's reliance on a general counsel memo, NLRB general counsel, not their own, memo that allowed for the disclaimer saying that the general counsel memo has no precedential value. So now, even when the general counsel offers this guidance, which they have done, and said, here's a sample policy, there's nothing that prevents the NLRB from saying, like, yeah, so what if we told you this would be okay? We don't mean it. Yeah. Whistleblowers, this is another area. OSHA and the NLRB have joined together to make sure that there are more opportunities to promote whistleblower claims, because OSHA has a very short statute of limitation for whistleblower claims, only 30 days. The National Labor Relations Act has a longer one, 6 months. So they've decided to try to work together so that if there are people who have time-barred OSHA complaints, when they come in and say something bad happened to me because I complained about unsafe working conditions, then they'll funnel them to the NLRA so that they can then say, oh, and complaining about my unsafe working conditions is protected activity, so this bad thing happened to me as a result of protected activity, that's an unfair labor practice, and bingo, you now have a valid and not time-barred claim, so you as an opportunity for people to, for example, get their jobs back, get back pay. So that's just a way that they're trying to expand the reach of the National Labor Relations Act. Another area where we're seeing a significant expansion is the NLRB decision in McDonald's case, where they issued 13 complaints against McDonald's, where basically what they found is that when you have a franchisee, the franchisor could be a joint employer. This is a huge expansion of the jurisprudence on joint employers, and it has been described within the franchising community that if this is upheld by the courts, and it's just too soon to really tell, but if this is upheld, that it could end franchising as we currently know it, because part of the reason that companies franchise, as opposed to individually opening all these branches, is to avoid this kind of liability. So if you're going to be on the hook and you don't have the control, there's really no advantage. So we'll have to see how that plays out. We have a fairly lengthy section in the materials on government contractors. I am not going to talk about them. We really put them here so that you have the information because it's of importance to anybody who has government contracts. Not everybody does, but there is a lot going on in the area of OFCCP, rulemaking. We've had a number of proposed rules. We have some final rules. We've seen a bunch of executive orders. We've seen some things going on here in Philadelphia at the local level. So if you have government contracts, please review those materials, and then if you have questions about them, please reach out to us, but we're not going to take everybody's time to talk about things that may only be applicable to a few people. So we're going to finish up today by talking about the other things that we're watching for 2015. So in the State of the Union address, we heard the President talk about his agenda, which was equal pay for men and women, increasing the federal minimum wage, revised overtime regulations, which we talked about, increased employment of military veterans, access to quality child care, and paid time off and paid maternity leave. Many of these things are going to require cooperation of Congress. It doesn't appear that that's likely to happen in a lot of ways, but we also see an agenda where the President has been trying to push as many of these things through executive order and through rulemaking of agencies as he can. So particularly in areas where there are government contractors or there are ways that existing laws can be interpreted or reinterpreted through rulemaking, we're going to continue to see very aggressive pushes by federal agencies to try to stretch the limits as much as they can to accomplish this agenda within their existing statutory authority. And so to the extent that they do that and agencies issue guidance that reinterprets the rules or even propose rulemaking and issue new rules, you know, I would expect to see legal challenges as we see with the ambush election rules that says, no, these rules are outside of your statutory authority. You don't make law, you interpret it. And we expect to see more in that. We talked about the NLRB and its activities. Well, this has led to this bill being introduced that would change the size of the NLRB and change its composition. Right now, the NLRB is 5 members, 3 representing the majority party, 2 the minority party in terms of the White House. The only agency where you explicitly have a federal composition that is specifically partisan in that way, but it means that basically, you know, the President's party can always win to the extent that he can get the nominees through the Senate, which has been an issue in past years. We actually have a full composition for the first time in many years, and we'll have that for a little bit longer until terms start expiring, but would change that and would create a 3-3, which means basically it's setting it up for a situation of deadlock, and also that terms would be created so that you'd have a Republican and Democratic nominees coming up at the same time. So if you want to get your nominees through, people theoretically are going to have less partisan, would also provide employers with the opportunity to appeal the decision to go to a complaint before the hearing. So you don't have to go through all the expense of a trial and then appeal to the courts afterward, but just even whether there's a legal basis for the complaint, it would be huge. You know, we'll see if it goes anywhere. I can't imagine it would be acceptable to the President. So I'm not holding my breath for that one, but it is interesting. There was also a appropriations bill in 2014 passed that had a rider prohibiting funding for any contractor found to have violated certain provisions of the FLSA. It was not passed, but we might see more of this activity, again, on this idea of trying to step up the enforcement of wage and hour in other ways than just sort of what DOL can do within its budget. In the area of regulations, the EEOC has put employers in a difficult position. We have the Affordable Care Act that encourages wellness programs. However, we've had the EEOC, which has arguably made many of those same wellness programs illegal under disability discrimination laws as it relates to participation incentives. The EEOC has offered no guidance on how to administer those programs without violating anti-discrimination laws. We're expecting regulations. Again, we say February 2015. hard to know what's going on with regulations these days. There have also been a number of for years there's been this talk of these so-called persuader regulations, which would require anybody who requires consultants, lawyers, anybody that an employer uses to persuade employees in organizing campaigns to register and do certain disclosures. There have been a lot of challenges, including the fact that it would violate attorney-client privilege because it would require lawyers to report. So this is something that the DOL still has on their regulatory agenda, and there's some thought that they're going to try and narrow this to avoid getting all of the lawyers mad at them. So we'll see with that. And we are finished, and we are happy to take any questions if anybody has them, either on the floor or you're welcome to come up and talk to us.
Shannon, the Facebook social media stuff is troubling, and I was wondering how far you think it could go. So if a movie theater employee posted that, the movie theater user would that still be permissible?
The question was, how far does the restrictions on social media go? And, you know, the example was if a movie theater employee posted on Facebook that the movie theater uses asbestos in posting its popcorn, in popping its popcorn, would that be protected? Under the view that's taken by the NLRB, I think that crosses the line. I think the NLRB would not have a problem saying, you know, that crosses the line. It's, you know, probably actually actionable defamatory speech and things like that. So there is a line where I think it's been harder for the NLRB and for employers is, you know, negative comments about supervisors and management, where people want to protect that, or, you know, they're just a crappy employer kind of comments, as opposed to specific assertions of wrongdoing where are likely not protected activity, particularly if they're wholly false. So, and, you know, different question if it's a whistleblowing type activity and if that would be protected under any state or federal whistleblower laws, which there's sort of a patchwork of. Thank you so much for joining us. Keep your eye out for future programs. We generally, I will do Harry's little pitch, we generally do these CLE for free monthly, and so keep your eye out for future programs. Thank you so much.